And hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you'll enjoy this legal education content, and today will be the day I earn that subscription. For today's story, we are going back in time and dealing with one of the oldest foundational cases in our great case series. This is the case of McCulloch versus Maryland, which deals with the authority of the U.S. government to have a centralized bank, which, of course, is the foundation for our modern Federal Reserve System. The Federal Reserve System was not, of course, our first national bank. We had several national banks before that, and this case deals specifically with the second national bank of the United States. So I'll give you a brief rundown of the case. In 1816, the Congress of the United States chartered what would be the second bank of the United States. In 1818, the state of Maryland passed legislation to impose taxes on the bank. So right away, you see the problem, right? The United States government has chartered a bank on behalf of the United States, right? Maryland wants to have taxes on the bank. That is a burden on the operations of the United States government. That's a problem. You can't do that, right? So McCulloch, who is the cashier of the Baltimore Bank, refused to pay the tax. So that's who McCulloch is. He is the guy who is the cashier, which in this context is the chief person. Cashier has a different definition than now. The cashier is the highest position in the bank. He's the person who actually creates the money. He's the treasurer, maybe would be the more modern equivalent. So he's the guy who runs the bank. So when it says cashier of the bank, he's the guy who runs the bank. So McCulloch refuses to pay this, right? The state's appeal court held that this tax was totally cool because the second bank of the United States was unconstitutional. Why? Because the Constitution does not provide a part of its text that says the government can have a bank. We've discussed this before. The federal government is a government of limited, enumerated powers. It only has as much power as it says it has. And one of the powers is not explicitly to create a bank. That is not one of the explicit powers. So it says, well, Congress can't really do this, so therefore it's not a burden on any sort of legitimate government operation because it's unconstitutional. So we're not going to pay the tax because our interest is sufficient. So therefore we get to the questions presented by this case. We have the question, does Congress have the authority to establish a bank and via proxy the Federal Reserve? And does the Maryland law unconstitutionally interfere with congressional power? That's the case. Okay, so we're going to do this, right? And so first of all, I like to read these cases in their original printed form, usually. But of course, this case is from 1819. So here's what the original printed form of the case looks like. I mean, I'm not sure what you would have expected. It's handwritten in a book. Because, it's 1819. So just by way of historical example, I thought that was kind of cool. That's the way it looks in the original. Just handwriting in a book, man. Handwriting in a book, which is pretty badass. All right, I think that's fun. All right, let's go past the original PDF. Let's go past the original PDF into a more modern equivalent that's a little bit easier to read. All right, so this is 1819. McCulloch, chief of the Baltimore Bank, on behalf of the United States versus Maryland. This is an error to the Court of Appeals for the state of Maryland. This is what we used to call it before we called it a writ of certiorari. We called it something else. Okay, so let's see if we can skip. Is this all syllabus? It can't possibly be. I guess it is all syllabus. Okay, well, it's a long syllabus. All right, so we can skip the syllabus. Skip the syllabus because, well, no, it goes on forever. This is just a long-ass syllabus. Today, syllabuses are more like 3 pages. There are still syllabuses today. They're just a lot shorter. So the act of 1816 to incorporate the subscribers to the Bank of the United States is a law made pursuant to the Constitution. So this is the summary. Now let's skip the syllabus. That's no fun. It's a spoiler. Let's go to the opinion of the court. In the case now to be determined, which is written by none other than Chief Justice Marshall, so some OG common law love over here. In a case now to be determined, the defendant, a sovereign state, which is Maryland, denies the obligation of law passed by the legislature of the Union, which is to say the United States, and the plaintiff, on his part, contests the validity of the act which has been passed by the legislature of that state. He'd like to, not pay the tax that Maryland says he has to pay. The Constitution of our country, in its most interesting and vital parts, is to be considered the conflicting powers of government of the Union and its members. That's federalism, basically, in short. The Constitution is, in many ways, a battle of power between the federal government and states governments in 1819 and today. The conflicting powers of government, as marked in the Constitution, are to be discussed, and an opinion given which may essentially influence the great operation of our government. A little bit, yeah. Can the United States have a bank or not? It might a little bit influence the operation of government. A little bit, yes. No tribunal can approach such a question without a deep sense of importance and the awful responsibility involved in the decision. It's consequential. But it must be decided peacefully or remain a source of hostile legislation, perhaps of hostility of still more serious nature. I mean, it's 1819. The issues over slavery are obviously relevant. And the Supreme Court is more than well aware of some tension in this time period regarding whether slavery should be legal or not. Ultimately would arise, of course, in the Civil War. So it's like, it would be nice if we could decide these issues peacefully, because the alternative is civil war. That's not so great. We prefer the peaceful solutions. And the Supreme Court tried to hold it together. I think in a lot of ways, some of their decisions, like in Plessy and Dred Scott and stuff like that, were attempts to hold it together. And so you can sort of empathize with their motivations, if not necessarily their reasoning. It's like, we are trying to do something to keep it all working together. And it's like, okay, well. So, I mean, it did ultimately resolve in 650,000 United States people dying. I believe it's still true that more people died in the Civil War than all other wars combined. It's close. But, yeah, it was a lot. Yeah. Anyway, so they're cognizant of that. And if it's to be decided peacefully by this tribunal alone, only we can make the decision finally in the end. On the Supreme Court in the United States has the Constitution of our country devoted this most important duty. The first question made in this case is, has Congress had power to incorporate a bank? That's a great place to start. Is this one of Congress's powers? Can they create a bank? Can they create a Federal Reserve? Is that something they can do? Good questions. It has been truly said that this can scarcely be considered an open question entirely unprejudiced by former proceedings of the nation respecting it. This question is not just occurring just in a vacuum. There is history that informs the question. The principle now contested was introduced at a very early part of our history, has been recognized by many successive legislatures, and has been acted upon by the Judicial Department in cases of peculiar delicacy as a law of undoubted obligation. So up to this point, we've been doing this. After all, this legislation deals with the second national bank of the United States, which, of course, tells you that there was a first national bank of the United States. It didn't work. The second national bank also didn't work. Ultimately would resolve in the Federal Reserve System that we know and love today, for all of its glory. It will not be denied that a bold and daring usurpation might be resisted after acquiescence, still longer and more complete than this. But it's conceived that doubtful question, one in which human resource may pause and the human judgment be suspended, in the decision of which the great principles of liberty are not concerned, but the respective powers of those who are equally representative of the people are to be adjusted, if not put at the rest by the practice of government, ought to receive a considerable impression from that practice. An exposition of the Constitution deliberately established by legislative act on faith, which immense property has been advanced, ought to not lightly be disregarded. Basically, we are going to presume that statutes of the Congress are constitutional, which is as much a presumption then as it is now. It is default practice that the courts will sometimes go a little bit out of their way to interpret statutes in a way that is constitutional. It's like if there's a plausible interpretation that's constitutional, the courts will reach for it, right? It's almost inevitably possible to find some sort of unconstitutional interpretation, right? You can give it a bad faith read, in other words. But the Supreme Court is going to give it a good faith read, the best faith read possible. We are going to find an interpretation of this that's constitutional, if at all possible. That's as much the law now as it is then. So that's what that's saying. The power now contested was first exercised by the first Congress, the very first one ever created a national bank. So, that's a little bit informative. I mean, it was literally the very first Congress created by the Constitution thought it had the power. So that's suggestive. Yeah. Not dispositive by any ways, but it's suggestive. If you want to ask the founding fathers what they thought, this is a pretty good way to ask them because, if they're still in Congress at this point. Its principle was completely understood and was opposed with equal zeal and ability. After first being resisted in fair and open field of debate, and afterwards in the executive cabinet, there was debate on the issue, with as much preserving talent as any measure has ever experienced. There are a lot of people on both sides of the issue who had some strong opinions, and being supported by arguments which convinced minds as pure and intelligent as this country can boast, it became law. Okay, it's a little bit of self-congratulatory language from the Supreme Court onto the Congress of the United States. You're just the best Congress, and you're such a smart and wise Congress, and through your power of fair and open debate, man, you came up with this brilliant thing that you've put in our lap. You are just the smartest and best Congress. We love you. The original act was permitted to expire. So, First National Bank of the United States had an expiration date on it. But after a short experience of the embarrassments to which the refusal to revive it exposed the government, convinced those who were more prejudiced against the measure of its necessity, it induced the passage of the present law. So, the First National Bank of the United States was designed to expire. It did expire. Its expiration led to problems. The Congress of the United States thought maybe let's do it on a more permanent basis, thus the Second National Bank. It would require no ordinary share of intrepidity, to assert that measure adopted under these circumstances was a bold and plain usurpation to which the Constitution gave no countenance. You're suggesting this is unconstitutional is asking a lot. These observations belong to the cause, but they're not made under the impression that, were the question entirely new, the law we found irreconcilable with the Constitution. So, yeah. So, our view of this, the court is writing, is somewhat informed by the history up to this time. If this were a brand new question, then maybe we'd come up with one answer. But, there's some history going on and perhaps some reliance interests would be the idea today. Maybe we have a reliance interest on this perhaps unconstitutional thing, and that's enough to keep it. This is also be part of the basis of why the Supreme Court doesn't always overturn its own precedents, incidentally. There are many reasons. That was discussed, for example, in the Dobbs case, and also discussed in O'Connor's opinion in the Casey versus Planned Parenthood case. Great opinion on reasons we do overturn cases, reasons we don't overturn cases. And reliance interest is one of those interests that classically gets referred upon. The degree to which people have made forward-looking things based on what the law is, right? It's like planning for the future. I want to plan for the future based on this thing. So if you've made plans like buying property or entering into contracts or something, and it's going to be disrupted by a change in law, that's a reason not to change the law. Reliance interest. Okay. In discussing the question, the Council for the State of Maryland had deemed it of some importance in the construction of the Constitution to consider that instrument not as emanating from the people, but as the act of sovereign and independent states. So there's one question for you that might make a difference. Is the Constitution of and by the people, or is it of and by the states? That's one question that one could ask. I mean, it is the United States, and the states were the ones that ratified it, so, but it does say we the people, so does that make a difference? It might. The powers of general government, it has been said, are delegated to the states. That's what we today call police power, and that remains true. General government, police power, right. And delegated to the states is not quite correct. Retained by the states is more correct in today's parlance, because there's no one to delegate it. That's why delegated is wrong. It's not delegated to the states, but, well, unless you say it was delegated by the people in the first instance, which I guess, but today we would say reserved by. Who alone are truly sovereign, and it must be exercised in subordination to the states, who alone possess superior dominion. Again, what is the balance between federal and state power? What is the role of federalism? What is the role of state government? What's the role of federal government? They're both sovereign. In what ways? When does one usurp the other? And so forth and so on. All kinds of fun questions by all kinds of fun things. It would be difficult to sustain this proposition. The convention which framed the Constitution was indeed elected by the state legislatures. I mean, duh, right? The state legislatures were the ones who sent their delegates to negotiate and ultimately sign off on the Constitution. Right. But the instruments which came from their hands was a mere proposal, without obligation or pretension. I mean, that's true. It wasn't binding the moment it was created. It had to be ratified. So, fair enough. So it was just a proposal at that point. Okay. It was reported then to the existing Congress of the United States, which this is one of those wonderful little factoids of American history. If you really want to blow someone's mind, right, you can remind them that there was a Congress of the United States before the Constitution, because there was a Congress of the United States under the Articles of Confederation. Also, incidentally, if you want to really trip someone up in a trivia contest, you can ask them who the first president of the United States was. And the Continental Congress had one-year presidencies. So I forget what the guy's name was, who was the president of the Continental Congress, the first president of the Continental Congress, which technically would be the first president of the United States. But if you really want to trip someone up, you can have fun with that sometime. Anyways, so it was reported by the then existing Congress of the United States with a request it might be submitted to a convention of delegates chosen in each state by the people thereof, under recommendation for the legislature for assent. So the people should vote on this. It should be approved by the people. The mode of proceeding was adopted, and under the convention by Congress and the state legislatures, the instrument was submitted to the people. They acted upon it in the only manner which can be acted safely, effectively, and wisely on such a subject by assembling in a convention. So they assembled in, a hall and had a discussion on it. It is true they assembled in several states, and where else should they have assembled? Each state had to vote on it separately. No political dreamer was ever wild enough to think of breaking it down the lines which separated the states and of compounding the American people into one common mass. Of consequence, when they had acted in their states, but the measures they adopt do not, on that account, cease to be measures of the people themselves or become the measures of state governments. So, to the extent that we care about such distinctions, and it could matter, this is a constitution created by we the people, not we the states. It is the people, according to the Supreme Court of the United States, that create the Constitution. And also the people, apparently, that it's implied, create the states in the first place. It is all the people. This is where it stops, right? It stops with the people. And so this is not in some ways perhaps similar to the EU, I suppose, in that way, where it's still their individual nation states that are voting on things. Here it's, the people of the United States each voting in what was their sovereign states as to whether or not there should be some sort of collective whole. So that's fun and exciting. By the way, for those of you who are new members, I did update the membership list on the screen today, so hopefully you'll see your name. Scroll by. I do try to update it fairly frequently, so just want to let you know that I updated it today. So if you were a member as of yesterday, at least, you should be on the list. From these conventions, the Constitution derives its whole authority. The government proceeds directly from the people, is ordained and established in the name of the people, and is declared and ordained in order to form a more perfect union, establish justice, ensure domestic tranquility, and secure the blessings of liberty to themselves and their posterity. Thank you, T. Ray, for your uncivilian membership, and thank you, Jennifer Foley, for your nice super chat. By the way, thank you, Lisa McFadder, for becoming a new member, and also to Lisa for $5 for saying, I love listening to your stream, sir. You do a good job. Thank you. And to Michelle Curl for $4.99 saying, good job, with a fox giving me a thumbs up. Badass. I appreciate the fox. What does the fox say? Apparently the fox says good job. So, mystery resolved. The assent of the states in their sovereign capacity is implied in calling the convention, and thus submitting the instrument to the people. But the people were at perfect liberty to accept or reject it, and their act was final. It required not the affirmation, and could not be negated by the state's government. So, the states couldn't say yes and couldn't say no. All that could happen was the people. The Constitution was thus adopted was of complete obligation and bound the state's sovereignties. It has been said that people already surrendered all their power to the state sovereignty and nothing more to give. So one of the arguments is, well, the states have what we today would call police power, and thus that's all the power to do all the things. Thus the people have no power. Thus only the states have power because they have all the power to do all the things, which doesn't leave much room for anyone else. So yeah, it could be. But surely the question may be whether they resume and modify the powers granted government does not remain to be settled in this country. Much more might be legitimately of the general government be doubted had it been created by the states. The powers delegated to state sovereignties, and again I suppose here we mean delegated by the people, were to be exercised by themselves, not distinct and independent sovereign created by themselves. To the formation of such a league was the Confederation. The state sovereignties were certainly competent. But when, in order to form a more perfect union, it was deemed necessary to change this alliance into effective government, possessing great and sovereign people and acting directly on the people. So, unlike the Articles of Confederation, where we might view the states as the ones participating, the distinction in the Constitution to form the more perfect union is that it's not the states, but rather the people themselves who are forming it, or at least that's the way the Supreme Court is characterizing it, which I don't know whether or not that's necessarily true or not, but it does have a certain romantic quality that I appreciate. I do appreciate the exaltation to the sovereignty of the people. Whether that's necessarily true as of between the comparison of the Articles of Confederation and the Constitution, I can't say, but I do appreciate the sort of romantic nature of it all. Okay. The government of the Union, by whatever influence is on the facts of this case, is emphatically and truly a government of the people. In form and in substance, it emanates from them. Its powers are granted by them in order to be exercised directly on them and for their benefit. Fair enough? The government is acknowledged to be the government is acknowledged to be by all one of enumerated powers. This is the key aspect of federalism. At least it seems to me, right? The states and the people, as the 10th Amendment reflects, have all residual power except that which was been expressly granted, which is to say, enumerated. The principle that can exercise only the powers granted to it would seem too apparent to have required to be enforced by all those arguments which its enlightened friends, while depending before the people, found it necessary to urge. The principle is now universally admitted, but the question respecting the extent of the powers actually granted is perpetually arising. Yeah, I mean, a little bit. The scope of the powers granted to the federal government is perpetually arising. Yeah, I mean, if that was true in 1819, it's definitely true today. And will probably continue to arise so far as long as our system shall exist. Well, so far, prophecy fulfilled. So far, prophecy fulfilled. In discussing these questions, the conflicting power of general and state governments must be brought into view, and the supremacy of their respective laws when they're in opposition must be settled. So this is one of the wonderful conflicts by having double sovereignty. The states are individually sovereign. The United States government is sovereign. So, how do you resolve that? Well, through much case law, apparently, was the answer to that question. Also, once through a civil war was also helpful in resolving that question, at least in part. If any one proposition could command the universal assent of mankind, we might expect it to be this: the government of the Union, through its though limited in powers, is supreme within the spheres of its action. That is definitely the law today as then, right? The Constitution says as much. It says it's the supreme law of the land. This is not controversial. Yes, when to the extent the federal government has power, it's supreme in that power. That is perfectly correct. The states may or may not have some power to act in some of those domains, but to the extent they have any power at all, the federal government necessarily usurps it in those domains. But in those domains is the key. This would seem to result necessarily from its nature. It's the government of all. Its powers are delegated by all. It represents all and acts for all. Though any one state may be willing to control its operation, no state is willing to allow others to control them. Yeah, because, if Maryland can control the United States, then Maryland can control the state of Pennsylvania, and Pennsylvania might not like that very much. So yeah, this is a problem. The nation, on those subjects in which it can act, must necessarily bind its component parts. But this question is not left to mere reason. The people have an express term decided by saying, the Constitution and the laws of the United States, which shall be made pursuant thereof, shall be the supreme law of the land. That's what the Constitution says. This Constitution and the laws of the United States, which shall be made in pursuance thereof, shall be supreme. What's supreme? The Constitution. Which laws? The ones that are made in pursuance thereof, which is to say, compatible with, which is to say, constitutional. So the laws of the United States must bow to the Constitution, and the Constitution bows to nothing. Right. Fair enough. And by requiring that members of the state legislatures and officers of the executive and judicial departments of the states shall take oath of fealty. That is part of the Constitution, too. Every state officer must take an oath of allegiance to the Constitution of the United States. The government of the United States, then, through its limited powers, is supreme. Or, though limited in powers, is supreme. Yes, it is supreme in the dimensions in which it has power. And its laws, when made in pursuance to the Constitution, form the supreme law. Anything in the Constitution or laws of any state to the contrary notwithstanding. That's as much true now as it was then. Among the enumerated powers, we do not find that of establishing a bank or creating a corporation. Those words certainly do not appear in the Constitution itself. But there's no phrase in the instrument which, like in the Articles of Confederation, excludes incidental or implied powers, and which requires everything granted shall be expressly and minutely described. This is true. There is the necessary and proper clause, and then what that means becomes a whole host of worms. When is it necessary and when is it proper? When is it necessary and proper? But yeah, there's nothing that expressly excludes implied powers, like the Articles of Confederation had. So the founders know how to wrote that, and they didn't. In fact, they kind of wrote the opposite to some extent. Even the 10th Amendment, which was framed for the purpose of quieting excessive jealousies when it's been excited, omits the word expressly and declares only the powers not delegated to the United States nor prohibited to the states are reserved to the states or the people. So yeah, it doesn't require it to be expressly delegated, just delegated, and that can be implicitly. And again, this seems to be something that they were making a very deliberate choice about because they were familiar with the Articles of Confederation, which seemed to have this problem, at least as they perceived it. Thus, leaving the question of whether a particular power may become the subject of contest has been delegated to one government or prohibited to the other to depend on fair construction of the whole instrument. We have to interpret the Constitution both as to its respective parts and as to its combined whole, because the Constitution obviously should be harmonious with itself. So to the extent that one provision of the Constitution might imply one thing, if it's in conflict with other parts of the Constitution, then it probably doesn't mean that. And that again remains true today as much as ever. And also incidentally applies to the Bill of Rights. So one of the things that you don't have this problem very much, but it does pop up occasionally. Pops up rarely. Where well, rarely might be overstretching, but you get my point. It pops up occasionally where a person wants an interpretation of usually a constitutional provision, usually it's a Bill of Rights provision, and they want a particular interpretation, but that interpretation, although plausible by the text on its own face, would run into some other problem somewhere in the Constitution. It would create a tension between two provisions in the Constitution. Thus, we try to avoid those interpretations. Again, avoid. It's not always possible, but we try. We try to interpret statutes in a way that doesn't create conflict with the Constitution. We try to interpret the Constitution in ways that doesn't create conflict with itself. Right? So, if all else being equal, we can find an interpretation where both articles are not infringed on the other, then fantastic. So, we are going to look at any provision in the Constitution, not only with respect to its own terms, but also make sure that it makes sense as part of the contemporaneous whole. That makes perfect logical sense. The men who drew and adopted the amendment had experienced embarrassments resulting from the insertion of the word in the Articles of Confederation and probably omitted to avoid the embarrassment. So they knew about the word expressly, they knew about the problems it caused, they probably excluded it for a reason. Okay. A constitution to contain an accurate detail of all the subdivision which its great power will admit, and by all the means by which it carried out into execution would partake a proxlicity of legal code, ooh, great word, and could scarcely be embraced by the human mind. The Constitution of the great state of Louisiana at this point would like to have a word with you because it goes on forever and ever and ever and ever and ever. And one thing you can't accuse the Constitution of Louisiana having a problem with is minute detail. Oh my God. Because they're a civil law system and they have to spell everything out in excruciating and painful detail. Is there anyone who understands the Constitution of Louisiana? I'm going to go with no, including the Supreme Court of Louisiana, because no one can retain that much shit in their own mind. We have enough problems with the entirety of the Constitution. Maintaining that in our own mind, it only goes on for like 4 pages. Trying to maintain, yeah, it's like this is not meant to spell out every detail. This is meant to spell out the most important details in the most important way, and go from there. Yeah, I think that's yeah. It would probably never be understood by the public. I mean, the public has enough problems with the Constitution as it is. We don't need to make it any longer. That's fair. Its nature, therefore, requires that its only great outline should be marked, its important objects designated, and minor ingredients which compose those objects be deduced from the nature of objects themselves. Okay, cool. I respect that. The Constitution is more of an outline than, a exact recitation of everything. So, okay, I can appreciate that. This idea was entertained by the framers of the American Constitution as not only be inferred from the nature of the instrument, but from the language. Why else was there some limitation found in the ninth section of the first article introduced? is in some degree warranted that by having omitted the use of any restrictive term which might prevent it receiving fair and just interpretation. In considering the question, then, we must never forget the Constitution we're expounding. That, of course, remains important, that we remember that we are, in fact, talking about the Constitution as we interpret things. Yeah. Although, among enumerated powers of government, we do not find the word bank or incorporation, we find the great powers to lay and collate. Okay, so we don't find the word bank or incorporation. Well, what do we find that might suggest bank or incorporation? What might suggest it? Well, what powers do we have? Well, we do have these powers: to lay and collect taxes, to borrow money, to regulate commerce, to declare and conduct war, and to raise and support armies and navies. Also to coin money, incidentally, which is not listed, but okay. The sword and the purse, all the external relations, and no inconsiderable portion of the industry of nations are entrusted to the government. It can never be pretended that these vast powers draw after them others of inferior importance merely because they're inferior. Such an idea can never be advanced. So just because there are inferior powers doesn't mean they automatically come along for the ride. Because if it did, that would be a problem, right? Because, well, think about it. Like, what is inferior to the power to declare war? Kind of everything, in a lot of ways. Like, if everything inferior to any power automatically came along to the ride, what is inferior to the powers to, for example, declare and conduct a war and raise armies? Like, everything. So it can't possibly be the case that everything that's being merely because it's inferior comes along for the ride, because that would be really, really dumb. That's what that's saying. Such an idea cannot be advanced, but it may, with great reason, be contended that a government entrusted with such ample powers on due execution, of which happiness and prosperity of the nation so vitally depends, must also be entrusted with ample means for their execution. So you have these powers. You must have the power to execute it. What kind of powers? Well, the necessary and proper ones, at least. And then we get into wonderful debates about what those are. That's where the fun begins. The power being given, it's in the interest of the nation to facilitate its execution. It can never be their interest, it cannot be presumed to have been their intention, to clog and embarrass its execution by withholding the most appropriate means. I mean, if there are multiple different ways of doing something, like, for example, coining money or raising an army or levying and raising taxes, if there's the most appropriate means of doing it, like the best way of doing it, then probably includes that, because that would be dumb if it excluded the best way of doing it. I mean, that's logical enough. Throughout the vast republic, from St. Croix to the Gulf of Mexico, from the Atlantic to the Pacific, revenue is to be collected and expanded, armies are to be marched and supported. The exigencies of the nations may require that treasure be raised in the north, should be transported to the south, that raised in the east conveyed in the west, or the order should be reversed. Yeah, we're a nation, and we might want to collect money from one place and spend it in another and move things around the nation, including the armies, for example, to fend off, whatever. That's pretty logical. Is that construction of the Constitution to be preferred, which would render these operations difficult, hazardous, or expensive? Can we adopt the construction unless the words imperiously require it, which would impute to the framers of the instrument, when granting these powers to the public good, the intention of impeding their exercise with withholding a choice of means? So, basically, if you have the power to do something, you can use just about any means that would help execute that power, as long as it's executing that power. We might get into issues about you dressing things up as being part of that power and saying, oh, what I'm really doing is really doing this, but it's not really what you're doing. But as long as it's what you're really doing, you're probably in the clear. Unless, of course, some provision in the Constitution explicitly forbids it. And that's, for example, the Bill of Rights, which goes a long way to forbidding quite a lot of means that might otherwise be implied. If indeed be the mandate of the Constitution we have only to obey, but the instrument does not profess to enumerate the means by which the powers it confers may be executed, nor does it prohibit the creation of a corporation. Fair. If the existence of such be essential or necessary and proper to the beneficial exercise of the powers, it is then a subject of fair inquiry for how far such means may be employed. What are the limits? And are you really doing this thing for that reason? Because you can only do it to exercise these powers, or are you dressing it up as something that's not really to try to pretend and get more power? So what is it really in reality? It is not to be denied the powers given to government imply the ordinary means of execution. That, for example, raising revenue and applying it to national purposes is admitted the implied power of conveying money from place to place as the exigencies of the nation may require, and employing the usual means of conveyance. So yeah, we have the ability to raise money and then spend money. So obviously we have the power to move money around from the place we collect it to somewhere else, as might be required. Like we collect money from one place and then we send it somewhere else to buy something, then ship to a third place for use in a fourth place, or whatever, right? So that makes logical sense. But it's denied that the government, thank you, Runkle the Bailey, and thank you to all the Runkle the Bailey members who are joining our channel. Appreciate that you're here. We are in the middle of the discussion of McCulloch versus Maryland, which is discussing the constitutionality of the second bank of the United States, and by extension, the constitutionality of the Federal Reserve System that we now have. Does the Constitution give them national authority to create some sort of national bank? That's the topic du jour. So let's go ahead and get back to this. Okay. But it is denied the government has its choice of means, or that it may employ the most convenient means to employ them, it be necessary to erect a corporation. On what foundation does this argument rest? So if forming a corporation, which today we'd probably call like an agency, if forming some sort of body that would execute that would be helpful, then why wouldn't you have the ability to do it, right? If you have the ability to collect taxes, for example, why not form an entity that would collect the taxes? For example, the IRS. If you're going to have postal roads, why not post offices and postal carriers and stuff? Okay. All those good stuff. $5 from Economath. You just listed a lot of things the sub-treasury can do. None of that implies a power to lend in competition with private banks. The private Federal Reserve doesn't lend in competition with, I don't know about the second bank of the United States, but the Federal Reserve doesn't give out loans except to banks. So they're not in competition. So I'm not quite sure what you mean, but thank you for your super chat anyway. Let's see, where were we? On this alone, the power of creating corporations, one appearing to sovereignty. Thank you, Marianne Williams, for gifting 10 memberships. That's very, very appreciated. Thank you. The original power of giving the law on any subject from whatever sovereign power, and if the government of the Union is restrained in creating a corporation as means for performing its function, on the single reason the creation of the corporate is an act of sovereignty, if the sufficiency of this reason be acknowledged, there be some difficulty in sustaining the authority of Congress to pass other laws for the accomplishment of some objects. So, this power necessarily speaks to other issues beyond this. There are a lot of powers in the Constitution that are expressly mentioned, and there are a lot of potentially implied powers. So the decision here would necessarily extend to all of Article 1, Section 8, for example, and other provisions besides that as well. The government which has a right to act and imposed on the duty of performing the act according to dictates of reason must be allowed to select the means, and those who contend it cannot select any appropriate means, then the one particular mode of expressing the objects is accepted to take upon themselves the burden of establishing the exception. So if you're going to argue that they don't have any power to do this except through one particular means, like why that one particular means as opposed to others. Economath gives $5 to say Federal Reserve loans to banks only as lender of last resort and the premium over federal funds rate. Yeah, that was my understanding. That's my understanding. Yeah, that they lend to banks as a lender of last resort. They're not in competition with banks. They lend to banks. So I appreciate that. And $2 from Lawn Lumber that says TOTC raid. Thank you for the TOTC raid. It is extremely appreciated. Thank you. The creation of a corporation, it said, appertains to sovereignty. That's admitted. So the corporation being created by the government of the United States must be relevant to the government's sovereignty because it's the one creating it. Fair enough. But to what portion of sovereignty does it appertain? Does it belong to more than one than the other? In America, the powers of sovereignty are to be divided between the government of the Union and those of the states. $2.99 from Trufflehound that says Runkle Raid. Thank you very much for the Runkle Raid bucks. It's appreciated. They are each sovereign with respect to the objects committed to it, and neither sovereign with respect to the objects committed to the other. Okay, yeah, this is, again, federalism du jour, right? The powers of sovereignty are divided between the government of the Union and those of the states. They're each sovereign. This is the American conceit. Each individual state is sovereign. The United States federal government is sovereign. How are they both sovereign at the same time? Because they have different objects committed to them. They have split the atom of sovereignty. Part of it's been given to the federal government, the remainder to the states. And so they're each sovereign with respect to those particular objects that are committed, and neither sovereign with respect to the other. And this is, again, true as much today as always. And this is one of the reasons that, the federal government has limited powers. It's one of the reasons, for example, the federal government cannot commandeer state-level authority. It's one of the reasons that the government, if the federal government, they want to act, usually has to do it itself or entice the states to cooperate because of exactly this. Crazy Cat Queen gifts 10 Uncivil memberships. Thank you very much for those gifts. Memberships is extremely appreciated. And thank you, Lawn Lumber, for gifting 10 additional memberships is extremely appreciated. As always, thank you, Rob, for your continued support and love. It means the world to me. Let us continue reading on some more. Also, incidentally, I am still willing to take shots for $200. So we can do this in any possible way that pleases anyone. Let me know. Let's see, where were we? We cannot comprehend that train of reasoning, which would maintain the extent of power granted by the people is to be ascertained not by the nature in terms of the grant, but by its date. Yeah, instead of like what came first, the issue is what power each has. The timing is not the relevant issue necessarily. Yeah. We cannot comprehend that train of reasoning, which would maintain the extent of power is determined by dates. Some state constitution were formed before, some since, that of the United States. Well, that too, because we've admitted other states since then. So if timing was an issue, then that'd be really complicated. Some states would have different power than other states, and that's not what we do. Sandra Ramirez gives 10 gifts memberships. Thank you very, very much for your continued support of the channel. It is appreciated. The respective powers must, we think, be precisely the same as if they'd been formed at the same time. Had they been formed at the same time, and had half the people conferred on the general government the power contained in the Constitution, and all states the whole residuum of power, would have been ascertained the government of the Union was not sovereign with respect to those objects which were entrusted to it, in relation to which laws were declared to be supreme. So, like, if we did this all contemporaneously, if all the states were formed at the same time as the national government, would it make any difference? The Supreme Court says no. The timing is irrelevant. It doesn't matter that some states were formed and they were formed at different times, and then a national government was formed, and then other states were formed after that, right? It doesn't matter. If all the states were formed at the exact same time and contemporaneous to the federal government of the United States, we would still have the exact same thing. Crazy Cat Queen says, do you have a Marlot or absinthe? I don't have Marlot, and I don't think I have any absinthe. No. I do have Knob Creek, which was what I was planning on doing. But I do have some gin. I have some whiskey. I think I have some vodka. That's not really my first choice. And I do have wine. So, and varying degrees. So I do have some options there. Okay. This could not be asserted. We cannot well comprehend the product of reasoning which maintains the power appertaining to sovereignty cannot be connected with that vast portion of which is granted to the general government, so far as it be calculated to serve the legitimate objects of government. The power of creating a corporation, though appertaining to sovereignty, is not, like the power of making war or levying taxes or regulating commerce, a great, substantive, and independent power which cannot be implied as incidental. I mean, yeah, if we're trying to rank relative powers of things, like creating a corporation is something I can do personally, individually, and I have. Uncivil Law LLC is up and running, which is producing this program. But I can't so much with the declaration of war. I cannot personally declare the war. So, no. But, so it's definitely not in the same tier. I don't think it doesn't have the same kind of consequences. It is never the end for which powers are exercised, but a means by which other objects are accomplished. So the creation of the corporation is not the end. It's just merely that facilitates something else. It's like creating the agency. Creating the body that's going to do this is not the end in and of itself. It's doing something else. Yeah. LLC is a limited liability company. You know what? Okay. It's still a corporate form. Okay. It's a form of corporation. Okay, let's just press on before I get into a fight with the chat. No contributions are made to charity for the sake of incorporation, but a corporation is created to administer the charity. No seminary of learning is instituted in order to be incorporated, but the corporate character is conferred to subvert the purposes of education. Thank you for all the orange hearts and cowboy hats, by the way. It's appreciated. No city was ever built with the sole object of being incorporated, but it's incorporated as affording the best means of being well governed. $200 from Crazy Cat Queen. Since you don't have Marlotte, or absinthe, and I presume you don't have moonshine, so 2 fingers of Knob Creek, my friend, neither on the rocks your choice. Well, you get 1 shot for $200, but I'm happy to oblige. But I don't have a shot glass, so we have to do it the hard way. Oh, it would be helpful if I took off the cap. If you took off the cap, it would probably work better. Cheers to you. Okay. I do have my water chaser today. Okay. Ooh, excuse me. Excuse me. But the Constitution of the United States has not left the right of Congress to employ necessary and proper means for the execution powers conferred on the Constitution to general reasoning. To enumeration powers is added that of making laws, which shall be necessary and proper for carrying into execution the foregoing powers, and all other powers vested by this Constitution in the government of the United States or any department thereof. So the Constitution does expressly contemplate the ability of the Congress to have additional powers not listed, those being necessary and proper, and then we get into wonderful contributions about what that is. Okay. The counsel for the state of Maryland has urged various arguments to prove that this clause, though general in terms a grant of power, is not so in effect, but really restrictive of a general right which otherwise might be implied in selecting the means for executing the enumerated powers. So they want to say the necessary and proper clause is not a grant of power, but actually a limitation on power, which seems like a very odd reading. I mean, yeah, that doesn't really work. In support of the proposition they found it necessary to contend, the clause was inserted for the purpose of conferring upon Congress the power to make law. That is, without doubt, might be entertained whether Congress could exercise power in the form of legislation. So they say that this clause was inserted to make clear that Congress can make laws. But without this, they wouldn't think that Congress could make a law. So Congress would have power to do these things, but not necessarily by passing laws without this clause. How else can Congress do things but by creating law? That's kind of what Congress does, so it doesn't make sense. But could this be the object for which it's inserted? No. A government is created by the people having legislative, executive, and judicial power. Its legislative powers are vested in Congress, which is to consist of a Senate and House of Representatives. Each house may determine the rules of its proceedings and declare that every bill which shall pass both laws shall, before it becomes law, be presented to the United States, the President. The seventh section of the Constitution, so yeah, the Constitution says how to make a bill. So this clause doesn't say, like, pass laws, because something else did with that. The seventh section describes the course of proceedings by which bills shall become law, and the eighth section enumerates the powers of Congress. Could it be necessary to say that the legislature should exercise legislative power in the shape of legislation? Yeah, that doesn't make any sense, Maryland. Try better. That doesn't make any sense. Ugh. This is hitting me a little rough. I'm going to switch to something else. Could it be necessary to say a legislature should exercise legislative power in the shape of legislation? After allowing each house to prescribe its own course of proceedings, after describing the manner in which a bill should become law, would have entered into the mind of a single member of the convention that an express power to make law was necessary to enable legislation? No, that's dumb. That a legislature endowed with legislative power can legislate is a proposition too self-evident to be questioned. No shit. But the argument on which most reliance is placed is drawn from peculiar language of the clause. Congress is not empowered to make all laws which may a relation to the powers, but only such as being made necessary and proper. And then we get into the debate. What do we mean by necessary and proper? It's not all power, it's necessary and proper. And what does that mean? And then you're just like, who do you ask for the next 200 years, basically, on that one? The word necessary is considered as controlling as the whole sentence, as limiting the right to pass laws for execution of granted powers to such that are indispensable, and without which power would be nugatory. That it excludes a choice of means and leaves to Congress each case only that which is most direct and simple. So here we're suggesting that necessary means strictly necessary, right? So it has been suggested that necessary means only that which would be truly required and thus excludes everything else. All right, so that's one idea. More water, please. Good call. Yeah, nugatory. It's a great language. It's a great word, isn't it? It would be nothing. It'd be null. It would be nothing. It is true that in the sense in which the word necessary is always used. So does it always mean this? Crazy cat queen gives me $10 to save water. Appreciate it. Thank you. Man, I'm not sure. Oof. Does it always import an absolute physical necessity so strong that one thing to which another may be termed necessary cannot exist without another? We think not. So we don't think by necessary they meant necessary in the strictest possible sense. Like without it, it can't possibly be. Like logically required. We don't think they meant quite that. Excuse me. If reference be had to its use in the common affairs of the world or in approved authors, we find it frequently imports no more that one thing is convenient or useful or essential to another. To employ the means necessary to an end is generally understood as employing any means calculated to produce the end, as not as being confined to those single means, without which the end would be entirely unattainable. So they think they meant it more in the sense of convenient to, or useful to, or essential to, which is, one way to interpret the word. And if you interpret it as strictly speaking necessary, I mean, that would be one hell of a limitation. And, perhaps too much. But this might be too open. So this is why we've had debates on this this is a debate on much as anything is the necessary and proper clause. And that's one of the reasons it's interesting. It's interesting because, what do we mean by necessary and proper? Do we mean necessary in the sense of, without this, it wouldn't work? Or do we mean this necessary in just a ordinary course of dealing kind of way? What is something necessary? Right, and be what is a necessary expense for the business of uncivil law? Do we mean without which uncivil law cannot function, or do we mean anything that would help to improve uncivil law? For example, lighting. Is lighting necessary? Right? Is buying a camera as opposed to a web camera necessary? Is getting lighting necessary? Well, I mean, the program could continue without those things. It just wouldn't be as good. So what do we mean by necessary, right? So these are examples of how we might mean things in our lives. T. Reed, the charity stream is 9 o'clock on Friday. So it should be a lot of fun. It'll be mostly me gaming. Although Rob will be joining us in the evening with Friday Night Frenzy, and that'll be kick-ass. And then he'll basically host his show on my channel and help to make my evening better. So I'm looking forward to all those things happening. So yeah, next Friday from 9 a.m. until at least whenever Rob is done with his show, which I will be hosting. Well, technically he'll be hosting it on my channel. We'll be doing a charity stream, and it'll be a lot of fun. And all proceeds that go through super chats will, of course, go directly to charity. It's gonna be a good time. Yeah, it'll be 9 a.m. It might be a little bit earlier. It might be a little bit earlier, but 9 a.m. till, at least 9 p.m. and probably more like 11. So it'll be at least 12 hours, probably more like 14. We'll see. To employ the words necessary to an end is generally understood as employing any means calculated to produce the end, and is not being confined to those single means by which without the end would be entirely obtainable. Such is the character of human language that no word conveys to the mind in all situations one single definite idea, and nothing is more common than to use words in a figurative sense. This is how the word literally stops being so, for example. Almost all compositions contain words which, taken in their rigorous sense, which convey a meaning different from that which is obviously intended. It is essential to just construction that many words which import something excessive should be understood in a more mitigated sense, in that sense which common usage justifies. The word necessary is of that description. It is not a fixed character peculiar to itself. It admits of all degrees of comparison, and is often connected with other words which increase or diminish the impression that the mind creates in the urgency of imports. This is fair enough, right? So the word necessary might strictly be speaking on its own terms unqualifiable, but that is not how we treat the word, right? We don't treat it as unqualifiable. We treat it as qualifiable because then we give it qualifications. For example, by saying necessary, very necessary, or absolutely indispensably necessary. Right. This is how we treat it in English. Which is also why, for example, a word unique, you can have a phrase like very unique which just strictly speaking doesn't make sense. Strictly speaking, of course, a thing can't be very unique, because unique is technically speaking unqualifiable, because something's either unique or not. But that's not how we treat it in English. So, fair. To no mind would the same idea have been conveyed by these several phrases. The comment on the word is well illustrated by a passage cited at bar from the 10th section of the first article of the Constitution. It is, we think, impossible to compare the sentence which prohibits a state from laying imposts or duties on imports or exports, except what may be absolutely necessary for executing its inspection law, with that which authorizes Congress to make all laws which are necessary and properly. So even in the Constitution itself, they qualify the term necessary, right? When they talk about imports, or duties, they talk about absolutely necessary versus necessary. So our founding fathers already qualified the word, so the word is qualifiable. So necessary, because this goes to a fundamental principle of interpretation. We don't interpret any word as being excessive. Like, every word has to have its meaning. So if you wrote necessary in one place and absolutely necessary in a different place, it is necessary that they mean different things. Otherwise, they would have written the same thing. So absolutely necessary can't mean the same thing as necessary, because if you did, it would treat the word absolutely as a duplicative, which it's not, because it can't be. So they must be different in scope. So, I mean, on some level, you can't fight that. On some level, that's just game, set, match, right? Whatever you think necessary and proper means, it can't mean absolutely necessary, because if it did mean absolutely necessary, they would have written absolutely necessary, because when they meant absolutely necessary, they actually wrote it. And so it can't mean that. It has to mean something else. It implies a more open form of the term. So, I mean, that's kind of game, set, match from basic, game, set, match from basic, like, statutory interpretation 101. We use the same word to mean the same thing. We use different words to mean different things. Congress wrote necessary and they wrote absolutely necessary. They must mean different things. Otherwise, the word absolutely is repetitive. So, it's kind of game, set, match a little bit on that one, yeah. We think it's impossible to compare the sentences which prohibit a state from laying imposts or duties on imports or exports, except what may be absolutely necessary from executing its inspection laws, with that which authorizes Congress to make all laws which shall be necessary and proper for carrying into execution the powers of the general government, without feeling a conviction. The convention understood itself to be changing materially the meaning of the word necessary by prefixing the word absolutely. Yeah. This word, then, like others, is used in a variety of senses, and its construction, the subject, context, and intention of the person using them are to be taken into view. I mean, that's on some level unarguable, because otherwise it renders a word redundant, and that can't be. The subject is the execution of those great powers on which the welfare of the nation essentially depends. It must have been the intention of those who gave the power to ensure, so far as human prudence could ensure, their beneficial execution. This could not have been done by confiding the choice of means to such narrow limits as to not leave in the power of Congress to adopt any which might be appropriate and which were conducive to the end. The provisions made in the Constitution intended to endure for ages to come, and consequently to be adapted to various crises of human affairs. To have prescribed the means by which government should, in all future time, execute its power, would have been to change entirely the character of the instrument and to give the properties of a legal code. So it would have been more along like what the U.S. Code provides, what the regulations provide, as opposed to a generalized architecture or generalized framework, which the Constitution is certainly more generalized than the U.S. Code. The U.S. Code goes on for a couple more pages than the Constitution. It would have been an unwise attempt to provide by immutable rules for exigencies, which, if foreseen by all, must have been seen dimly, and which can be best provided for as they occur. To have declared the best means shall not be used, but by those alone by which the powers given would be a nulligation, would have been to deprive the legislature of the capacity to avail itself of experience, to exercise reason and accommodate legislation to circumstances. So, if all Congress could do would be that which would prevent it from being completely nullified, it would prevent the Constitution itself from enduring, because the Constitution would not be able to adapt to changing circumstances and changing times. And the Constitution is meant to adapt because it only provides frameworks. It doesn't provide details, because the details can be filled in as needed, as needs change. And, you could imagine if the power to coin money, if that was restricted the same way it was in 1780, how limiting that would be. 1788, how limiting that would be. Or the power to run postal roads. If the power to run postal roads was the same power in 1790 or 1788 as it is today, my God, we wouldn't be able to have mail trucks. We wouldn't be able to have aircraft. We'd still be stuck with horse and buggy, because that's all that was provided for, because they wouldn't be able to see anything else. And so, we're not going to interpret that broadly. It's meant to adapt with the times. I mean, that seems pretty logical. Where was I? If we apply the principle of construction to any powers of government, we shall find it so pernicious in its operation that we shall be compelled to discard it. So if we actually tried to do this, it would be so all-encompassing that we couldn't do it. It would be unworkable. The powers vested in Congress may certainly be carried into execution without prescribing an oath of office. The power to exact this security for faithful performance of duty is not given, nor is indispensably necessary. The different departments may be established, taxes may be imposed and collected, armies and navies may be raised and maintained, and money may be borrowed without requiring an oath of office. It may be argued that as much plausibility as other incidental powers have been assailed, the convention was not unmindful of the subject. The oath of which might be exacted, the fidelity of the Constitution is prescribed, and no other can be required. Yet he would be charged with insanity who could so contend the legislature might not superadd to the oath directly by the Constitution such other oath of office as wisdom might suggest. So it's like, no. So with respect to the whole penal code of the United States, whence arises the power to punish in cases not prescribed by the Constitution? All admit the government may legitimately punish any violations of its laws, and yet this is not an enumerated power. So yeah, the power to punish is not an enumerated power, but they have the power to pass laws. So everyone admits that would be necessary. Law and Lumber gives 10 additional memberships. Thank you very much. Yeah, super ad internet commentary. Yeah, that's an old school word. But yeah, that's a good one, isn't it? Super ad. Some of these words are really cool. You don't see that every day. To add to that which is already added. Super ad, yeah. The right to enforce the observation of law by punishing its infraction might be denied with more plausibility because it be expressly given in some cases. Congress is empowered to provide for the punishment of offenses for punishment of counterfeiting the securities and coin of the United States, and defend and punish piracies and felonies committed on the high seas and offenses against the laws of the nations. The several powers of Congress may exist in a very imperfect state, to be sure, but they may exist and carried into execution, although no punishment should be inflicted, in cases where the right to punishment is not expressly given. Take, for example, the power to establish post offices and roads. This power is executed by the single act of making the establishment. But from this has been inferred the power and duty of carrying the mail along a post road from one post office to another. Right. So they have the power to establish the post offices by the Constitution, and the ability to establish the roads. But it doesn't expressly say that they have the power to carry mail from place to place. But I mean, come on. Of course they do. And apart from this implied power has been again the right and further right to punish those who steal letters from the post office or rob the mail. It may be said with some plausibility the right to carry the mail and punish those who rob it is not indispensably necessary to the establishment of a post road and post office. I mean, I guess strictly speaking not. I mean, you can have a post road and a post office without punishing people who steal mail, but, kind of dumb. Super ad means the whole exceeds the sum of its parts. Does it, Economath? Okay, well, in that case, I had an incorrect definition of super ad in my mind. I appreciate the correction. Thank you. We all learn something new here on Uncivil Law, and I don't mind being corrected. We all learn something new. So super ad means the whole exceeds the sum of its parts. Cool. We learned something. Kick ass. And apart from the implied power has again been inferred the right to punish those who steal letters from the post office or rob the mail. It's been said with some plausibility that the right to carry the mail and punish those who rob it is not indispensably necessary. The right is indeed essential to beneficial exercise of the power, but not indispensably necessary. So of the punishment of the crimes of stealing or falsifying a record, or process of the court of the United States, or perjury, to punish those offenses is certainly conducive to due administration, but courts may exist and decide causes brought before them, though such crimes would escape punishment. The baneful influence of this narrow construction upon all the operations of government and the absolute impracticality of maintaining it without rendering the government incompetent to do its great objects might be illustrated by numerous examples drawn from the Constitution and from our laws. Again, right, if this is true, what else is true, right? This is showing why this can't be true by showing where the argument leads. Like, if Congress doesn't have the power to raise the banks, what else does it not have the power to do? Does it not have the power to punish offenses on the postal roads? Does it not have the power to, punish perjury? What else doesn't have the power to do, right? And it's like, these seem untenable. It seems illogical. It's like, yeah, I mean, I appreciate that. The good sense of the public has been pronounced without hesitation. The power of punishment appears to sovereignty and may be exercised whenever the sovereign has the right to act as an incidental of constitutional power. It's a means for carrying into execution all sovereign powers and may be used, although not indispensably necessary. It is a right incidental to the power and conducive to beneficial exercise. If the limited construction of the word necessary must be banished in order to punish, whence is derived the rule which would reinstate it when the government would carry its powers into execution by means not vindicative of its nature. So yeah, if the word necessary doesn't prevent Congress from punishing offenses against the United States, then why is it limited here if it's not limited there? What are the limits of your doctrine, Maryland? And there's no apparent limits, and then you run into problems. If the word necessary means needful, requisite, essential, conducive to, in order to let a power or punishment for the infraction of law, why is it not equally comprehensive when required to authorize the means to facilitate execution power without infliction of punishment? Fair. In ascertaining the sense by which the word necessary is used in the clause of the Constitution, we may derive some aid from that which is associated. Congress shall have the power to make all laws which may be necessary and proper to carry into execution the powers of the government. If the word necessary was used in a strict and rigorous sense, for which the Council of Maryland contends, it would be an extraordinary departure from the usual course of the human mind, as exhibited in composition, to add a word the only possible effect of which is to qualify that strict and rigorous meaning, to present the mind the idea of some choice as a mean of legislation not strained and compressed within narrow limits. But the argument which is most conclusively demonstrates the error of the construction contended for by Maryland is founded on the intention of the convention as manifested in the whole clause. To waste time in argument in proving that, without it, Congress might carry its powers into execution would not be so much less idle than wholly lighted taper to the sun. That's wow. To waste time improving it would be like holding a lighted torch towards the sun. Not very effective. That's nice language. As little as can be required to prove it in the absence of a clause, Congress would choose some other means, that it might employ those which, in its judgment, which would most advantageously affect the object to be accomplished, that any means adapted to the end, any means which be tended directly to execution constitutional powers of government, were themselves constitutional. The clause, as constructed by Maryland, would abridge and almost annihilate the useful and necessary right of the legislature to select the means. That could not be intended is, we should think, has not already been controverted too apparent for controversy. We think so for the following reasons. The clause is placed among the powers of Congress, not among the limitations of its powers. Fair. Its terms purport to enlarge, not diminish, the powers invested by government. It purports to be an additional power, not a restriction on power already granted. Yeah, it does seem to be an addition. No reason has been or can be assigned for thus concealing an intention and narrow the discretion of the national legislature under the words which purport to enlarge it. The framers of the Constitution wished its adoption and knew well that it would be endangered by strength, not by weakness. Had it been capable of using such language which conveyed the idea to the eye, one idea, and after deep reflection, impression on the mind another, they would have rather disguised the grant of power than its limitation. If then their intention had been, by this clause, to restrain the free use by which otherwise might have been implied, that intention would have been inserting in any other place, and would have been expressed by terms resembling these. In carrying out the execution of the foregoing powers and all others, no law shall be passed but those that are necessary and proper. Had the intention been to make this clause restrictive, it would unquestionably have been in so form as well of effect. So again, if they meant this in a more restrictive way, they would have done it, and they did do it in a different clause in the Constitution, which shows they do know how to do it when they want to and didn't mean to do it here. So this is meant to be an additional grant of power, not a limitation. It's in the section with grants of power, not limitations. It's an additional power. It's not strictly necessary because we already have language dealing with that somewhere else. They could have written this more clearly if that's what they wanted, and they have somewhere else. So makes all logical sense to me. Yeah, it makes all logical sense to me. The result of the most careful and attention consideration bestowing upon this clause is, if it does not enlarge, it cannot be construed to restrain the powers of Congress or to impair the right of the legislature to exercise its best judgment in selection measures to carry into execution the constitutional power. If no other motive for insertion can be suggested, a sufficient one is found in desire to remove all doubts respecting the rights of the legislature on vast mass of incidental powers which must be involved in the Constitution if the instrument it be not splendidly bauble. If the instrument be not a splendid bauble. So just not a pretty thing. If it actually have a fact, it must be this. I like that. I like that. If the instrument is not to be a splendid bauble. That's cute. I kind of like that. It's not just a pretty thing. It's meant to have some heft to it. I like that. We admit, as we must admit, the powers of government are limited, and its limits are not to be transcended. But we think the sound construction of the Constitution must allow to the national legislature that discretion with respect to the means by which the powers it confers are to be carried out into execution, which will enable that body to perform the high duties assigned to it in a manner most beneficial to the people. Let the end be legitimate, let it be within the scope of the Constitution, and all means which are appropriate, which are plainly adapted to that end, which are not prohibited, but consistent with the letter and spirit of the Constitution are constitutional. And that is basically the rule as it is today, right? And then you get into basically rational basis, right? Most of the time, we look to rational basis as our standard, right? Any reason will do, any legitimate method and any legitimate means is the normal interpretation. Where the legitimate ends, the one specified by the Constitution. Where the legitimate means, well, basically any that's not otherwise prohibited. And so, yeah, that's probably the standard now as it is today. Right? And so what's left? What can't Congress do? Act arbitrarily and capriciously, right? It has to have a reason. Any reason will be fine. It doesn't necessarily have to be the reason they state. That's normally the way it goes. Sometimes the government fails at even that, but not very often. So, yeah. Frank says, you love my great cases series. Thank you. I find it extremely informative because it speaks to foundational principles, right? This case is, as the Supreme Court itself is writing, right? As the Supreme Court itself acknowledged in its own opinion, this case is not just about the Bank of the United States. And, pretty much, and most cases are not just about one thing. They're about multiple different things because, again, we work on a common law system and things are precedential. And so what would be true here as it relates to the Bank of the United States must necessarily be true under other provisions of the Constitution because we're talking about the necessary and proper clause. So whatever limitations it does or does not have in this domain must be true in all the domains, right? And so so they recognize that. And so reading this understands the foundation of not only the National Bank and the Federal Reserve that would succeed it and why that's there, but also helps you understand the necessary and proper clause more generally, how it's understood. And this foundation is basically the same today. It's basically the same today, right? Under normal rational basis review, which is your typical go-to for most acts of Congress, right? We only talk about heightened levels of review when we're talking about constitutional interests, right? So most things the government don't imply Bill of Rights, right? The Bill of Rights is by far the exception, not the rule. So most things that the state legislature do, or most things that Congress do, the vast majority of them only imply rational basis review. Any legitimate method, any legitimate means for any legitimate end. What are the legitimate ends? The ones specified in the Constitution, if you're the federal government. Every other possible end, if you're the state government, right? So of all the ends that could be, what ends? Well, the ones listed if you're the federal government, literally everything else if you're the state government. What possible means? Everything that's not prohibited. As long as there's a reason that's rational. Any reason will do. So it's very important because it helps you understand the foundations of American law. And it kick ass. And, the language, once you translate the language a little bit, but I mean, it's written in English. And the language is a little bit different in 1819. Language is a little bit different, but, it's easily readable. Once you translate a word here, translate a word there, you can parse it in modern English. It makes total logical sense. This decision could be written today. It would be written differently today, but it's perfectly logical. So I'm glad you like it. It's good to show these foundations. Economath says, I should clarify, my beef with the case is about necessary. It's that the lending power given to businesses, not the same power as Fed, was not proper. Okay, noted. Fair enough. That's, I appreciate your super chat, and regardless, and I appreciate you being a thoughtful contributor to the channel. I appreciate you, Economath. Thank you. Oh, two businesses was the second Bank of the United States. The lending power given the second Bank of the United States, not the same power as the Fed, wasn't proper. I don't know enough about the lending power of the second Bank of the United States to intelligently comment on that particular aspect, so you might have me on that one. So I'll defer to you on that one because I don't have enough knowledge about what lending power they did or did not have. But thank you very much. KM says Kurt is holding back right now. Am I? Am I holding back? I don't know. I thought I was doing good. All right. That a corporation must be considered as a means not less usual, nor of higher dignity, not requiring more than a particular specification than other means has been sufficiently proved. If we look to the origin of corporations, to the manner in which they've been framed in that government, from which has derived most of our legal principles and ideas, or to the uses to which they've been applied, we find no reason to suppose that a constitution omitting, and wisely omitting, to enumerate all the means for carrying into execution the great powers vested in the United States ought to be specified in this. Had it been intended to grant this power as one which should be distinct and independent, to be exercised in any case whatever, it would not have found a place among enumerated powers of government, but by being considered merely as a means to be employed only for the purpose of carrying into execution the great powers, there could be no motive for the particularly mentioning it. Fair enough. I mean, that makes logical sense. I think that makes logical sense. Life on Leo says, as a foreign lawyer, learning American law, your series has been helpful. I passed the Texas bar 5 years ago, but never practiced, so I've forgotten almost everything. Well, I'm glad I could help. I'm glad you find this series useful. The Treasury sits right next to the White House, not the Federal Reserve. I'm not sure where the Federal Reserve sits, if it sits in D.C. But anyways, it's not important. The propriety of the remark would seem to be generally acknowledged by the universal acquiescence in the construction which has been uniformly put on the third section of the fourth article of the Constitution. The power to make all needful rules and regulations respecting the territory or other property belonging to the United States is not more comprehensive than the power to make all laws which shall be necessary and proper for carrying into execution the powers of the government. Yet all admit the constitutionality of territorial government, which is a corporate body. If a corporation may be employed indiscriminately with other means to carry into execution the powers of government, no particular reason can be assigned for excluding the use of a bank, if it be required. And the second bank is right next to that? Okay, cool. I didn't know that. To use one must be within the discretion of Congress if it be an appropriate mode of executing the powers of government, that is, a convenient, a useful, and essential instrument in the prosecution of physical operation, is now not a subject of controversy. All those who have been in concern in the administration of our finances have concurred in representing its importance and necessity, and so strongly have been felt that statesmen of the first class, which previous opinions held against it, have confirmed by every circumstance which can fix the human judgment, having yielded those opinions to the exigencies of the nation. Under the Confederation, Congress, justifying the means by necessity, transcended perhaps its powers to obtain the advantage of a bank, and our own legislation attests to the universal conviction of the utility of the measure. So again, looking to the historical analysis and the Confederation by way of example, by why this might be something that makes logical sense. The time has passed away when it can be necessary to enter into any discussion or to prove the importance of this instrument as a means to effect the legitimate objects of government. But were its necessity less apparent, none can deny it being of appropriate measure, and if it is, the decree of necessity, as being very justly observed, is discussed in another place. Economath gets $5 to say happy to support. I should also concede that Maryland didn't challenge the second Bank of the United States on that ground, so I can't fault C.G. Marshall for not really addressing it. Yeah, no joke, right? If you're not going to complain about it, they're not going to raise the issue. So, I mean, like, the Supreme Court doesn't usually, although it does occasionally, but, well, very rarely. But yeah, usually if you don't raise it, the Supreme Court's not going to consider it. They're only going to consider what you ask, typically. But thank you for your super chat. Should Congress, in execution of its powers, adopt measures which are prohibited by the Constitution, or should Congress, under the pretext of executing its powers, pass laws for the accomplishment of objects not entrusted to the government? So again, like, we can look beyond what Congress calls it to what it is, right? This is in furtherance of the postal roads, but if it has nothing to do with that, right, we're not going to be dumb. So if you adopt measures which are prohibited, or you try to pretend this is one thing when it's really not that thing, It would become the painful duty of this tribunal, should such a case requiring a decision, to say the act was not the law of the land. So, yeah, if you do something the Constitution doesn't allow, or if you try to say, well, it's really this when it's not that, then no, we're going to say, no, you can't do that. That's not going to fly. But where the law is not prohibited and is really calculated to affect any objects entrusted to the government, to undertake here the inquiry into the degree of necessity would be passing a line which circumscribes the judicial department and tread on legislative grounds. So if we got into the degree of necessity, we would be acting as a legislature. And we already know that it's, anything that we'll do will be fine. And so we don't normally do that. So we only look to see if you've exceeded your power, or if you've pretended it's your power when it's really not, or if it's arbitrary and capricious, like there's no rationale for it. But otherwise, we're not really going to get into it. This court disclaims all such pretensions to the power of the legislature. After this declaration, it can scarcely be necessary to say the existence of state banks can have no possible influence on the question. So state banks, sure, they're whatever, but that has nothing to do with the national bank. No trace is to be found in the Constitution of an intention to create a dependency of the government of the Union on those of the states for execution of power. So states might have banks, but the federal government doesn't have to use individual state banks. They can have their own bank. They don't have to resort to the Bank of Maryland, who might be in a position to control them through exercise of that. It's like, that'd be stupid. Its means are adequate to the ends, and on those means alone it was expressly to rely on accomplishment. To impose on it necessity of resorting to means which it cannot control, which another government might furnish or withhold, would to render its course precarious, to the result of which is uncertain and creates dependency. So yeah, if we said that, it's just not a problem because you can use the banks established by Maryland or by Virginia or Pennsylvania, then that'd be a little bit dumb, because that gives a lot of power to Maryland or Virginia or Pennsylvania now, doesn't it? Who then might be in a position to withhold their cooperation or put terms on it or whatever, right? It's like, once you control their money, right? So it's like, that would be a problem, because we can see where that's going. And that would be incompatible with the language of the Constitution. Were it otherwise, the choice of means implied the right to choose a national bank in preference to state banks, and Congress alone can make that election. So Congress might want banks it controls, so it doesn't have to yield to the sovereignty of the individual states when it comes to the moving of its money. I mean, that kind of makes sense. So you can view this as necessary to the spending power. You can view this necessary as the taxing power. You can view this as necessary to the... Can you imagine if they had to use state banks, how that might influence the taxing power? Holy God. You can view this as necessary to the coinage of money. You can view this as necessary to a lot of things, right? That the federal government has the ability to spend money, raise money, control money, not have it hijacked by another sovereign. I mean, there's a lot there. Generous says, love you, Kurt. You teach me new things every time I see you. I'm in awe of your knowledge, your reading comprehension, and how you retain all the things in your brain. Amazing, simply amazing. Well, thank you. I really appreciate that, Generous. I really appreciate it. I work very hard at it so that I can understand and explain it and recharacterize it and try to show you the foundations of government. And this is a foundational case. It goes to the power of Congress in a very fundamental way. Pretty much the existence of agencies at basically full stop. Right. And so yeah, I appreciate it. Paige says, I started watching you during DEP and took a break. Oh my goodness, you're so different. So I can tell you're much happier. Glad to see it. Thank you. Thank you. I'm a lot happier since I left my job. And even though the last 3 days have been a little bit rough for me, because anyone who's dealt with depression knows that not every day is going to be great, and you can't always figure out the reason why. So even though I've been a little bit down the last 3 days, the overall trend has been up, and I really appreciate that you guys are here and helping me make my dreams come true. It's with your support and love and your super chats and your memberships and your other contributions and your time and your energy and helping to help other people learn about the channel and support. And it's with the cowboy hats and the orange hearts and everything that this becomes possible. And I appreciate your love. Thank you. You're starting to use stand-up comedy as therapy? Not a bad idea. I'd like to take a class on stand-up comedy. That could be fun. I took a lot of classes on improv, and I enjoyed that. There's got to be some classes on stand-up comedy, right? Like learning stand-up comedy, I'm sure has rules, just like improv has rules. And they can teach you the rules, and then you work on your sets and you go from there. I'm sure a lot of people divine it, but it'd be helpful to take a class. I really need to look into classes on stand-up comedy. How to be a stand-up comic 101. That'd be fun. Yeah. The branches proceeding from the same stock as being conductive to the complete accomplishment of the object are equally constitutional. It would have been unwise to locate them in the charter, and it would have been unnecessarily inconvenient to employ the legislative power in making the subordinate arrangements. The great duties of the bank are prescribed. Those duties require branches, and the bank itself, we think, may be safely trusted with selection of places where those branches shall be fixed, reserving always the right to the government to require that the branch be so located when it deems necessary. It being the opinion of this act that incorporating a bank is constitutional, and the power of establishing a branch in Maryland might be properly exercised, we propose to inquire the next question: whether the state of Maryland may, without violating the Constitution, tax that branch? Now, the answer today is hell no, right? We've discussed this. The states cannot burden the federal government, nor are they required to help. They don't have to help, and they can't burden them. So, can a state tax the federal government? No. They can tax federal employees, but they can't tax the federal government. No, not so much, no. So, let's read a little bit about the no. That the power of taxation is one of vital importance that is retained by the states, that is not abridged by the grant of similar power to the government of the Union, that is to be concurrently exercised by two governments, are truth, which is never denied. Both the states and the federal government have taxing authority. Right. But it's of such paramount character of the Constitution that its capacity to withdraw any subject from the action of even power is admitted. $20 from Jennifer Edwards. As a fellow sufferer of depression, I understand not every day is a good day. It's okay not to be okay. Just keep being the Kurt we love. Cowboy hat. Kick ass. Thank you. And Kendra Strike gives me $6.99 Canadian. You're a good guy. Thanks for always reading and responding to my non-super chats during your streams. You failed to disappoint me. Excellent. I try to read the non-super chats from time to time, obviously, because usually I'm engrossed in reading and explaining. But as my attention occasionally diverts to see what's going on in chat or otherwise, I do like to acknowledge the non-super chats along the way. So normally, as the super chat comes in, obviously it's going to cause my attention to pop over because, that's why you're giving them. But, from time to time, I do like to read the non-super chats as they catch my attention. I want to give back to everybody. Super chats obviously get priority, but I want to try to give to everyone, as long as the super chats don't become so overwhelming, So someday it will probably be necessary to only read super chats, but until that day comes, I'll try to do my best to acknowledge everybody. Where was I? Okay. Let's see. The states are expressly forbidden to lay any duties on imports or exports except that which may be absolutely necessary for executing their inspection laws. If the obligation of this prohibition must be conceded, if it may restrain a state from the exercise of its taxing power on imports and exports, the same paramount character would seem to restrain, as it certainly may restrain, a state from other exercise of power as by its nature incompatible with and repugnant to the constitutional laws of the United States. A law absolutely repugnant to another as entirely repeals that other as if express terms of repeal were used. Trufflehound gives Australian $7.99. Kurt, to brighten your day, I sent you a beef fish on the tweets. They're going crazy for the cherry trees. Excellent. Thank you very much. The beef fish are always appreciated. Thank you very much. On this ground, the counsel for the bank placed its claim to be exempted from the power of a state to tax its operation. There is no express provision for the case, but the claim has been sustained on a principle, which so entirely pervades the Constitution, it is so intermixed with the materials which compose it, so interwoven with its web, so blended with its texture, as to be incapable of being separated from it without being ripped into shreds. The great principle is that the Constitution and laws made in pursuance thereof are supreme. They can control the Constitution and laws of the respective states and cannot be controlled by them. That's what the Constitution says. The laws made pursuant to the Constitution are supreme. The Constitution is supreme. So a state law and state constitution obviously can't usurp them, because that would be really stupid. From this, which may also be termed an axiom, other propositions are deduced as corollaries, on truth or error of which, and on their application to this cause, the cause so supposedly depends. These are, first, that power to create implies a power to preserve. That power to destroy, if wielded by different hands, is hostile to and incompatible with power to create and preserve. Yeah, if a different entity has a power to destroy versus the power to create, if those are two different entities, then the person with the power to destroy could be hostile to the person with the power to create. That could be a bit hostile. If the power to create and the power to destroy are held by two different people, the power to destroy might be exercised in a somewhat hostile way to the power to create. Yeah. That, when this repugnancy exists, that authority which is supreme must control, not yield to the other. Yeah, whatever is supreme must win. Deep Thoughts by John Handy. Okay. These propositions, as abstract truth, would perhaps never be controverted. Their application in this case, however, has been denied. And that's where you go, what? Because, this is stupid, right? It's just stupid. The Constitution is supreme. Any laws passed pursuant to the Constitution are supreme. All the state constitutions and state statutes must necessarily bow to it to the extent required. But Maryland says, not here. We can tax. And the power to tax is definitely the power to destroy. Their application in this case has been denied, and both in maintaining the affirmative and negative, a splendor of eloquence and strength of argument seldom, if ever, surpassed has been displayed. So apparently Maryland was really good in its oral arguments. The power of Congress to create and, of course, to continue the bank was the subject of the preceding part of this opinion, and is no longer considered as questionable. We've resolved that issue. Moving on. The power of taxing by the states may be exercised so as to destroy is too obvious to be denied. I mean, all you have to do is levy 100% tax and you're there. And in a practical matter, not even necessarily 100% tax. A lot of other taxes will do quite nicely if you want to destroy something. But taxation is said to be an absolute power which acknowledges no other limits than those expressly prohibited prescribed in the Constitution, and like sovereign power of every other description, is to be entrusted to the discretion of those who use it. So taxation is absolute. No. I mean, no. Yeah. But the very terms of this argument admit the sovereignty of the state in the article of taxation itself is subordinate to and may be controlled by the Constitution of the United States. You think? Yeah. How far has it been controlled by the instrument must be a question of construction. In making this construction, no principle not declared can be admissible which would defeat the legitimate operation of the supreme government. We're not going to interpret the Constitution in a way that would give states or localities power to impede what are legitimate operations. We can get into what legitimate operations are, and we will many times for the next 250 years. But, whatever those limits are, once they're established, is the very essence of supremacy to remove all obstacles to its action within its own sphere, as to modify every power vested in subordinate government. That would be the nature of the sovereign. Yeah, the sovereign can naturally just naturally overtake any subordinate, because that's the power of the sovereign, is to be sovereign. The sovereign is sovereign, says the Supreme Court. Deep thoughts from Jack Handy. The effect need not be stated in terms. It's so involved in a declaration of supremacy, so necessarily implied that the expression of it could not be more certain. Sovereign is sovereign. Find out more at 11. Our film starts at 11. Is your sovereign sovereign? Tune in tonight at 11 o'clock. We must therefore keep in view when construing the Constitution, the argument on the part of Maryland is not that the states may resist a law of Congress. Oh, good. But they may exercise their acknowledged powers on it, and the Constitution leaves them this right in confidence they will not abuse it. Yeah, right. But our power is absolute, so even if we did abuse it, it wouldn't matter either way. Before we proceed to examine this argument and subject to the test of the Constitution, we must be permitted to bestow a few considerations on the nature and extent of this original right of taxation, which is acknowledged to remain with the state. It is admitted the power of taxing people and their property is essential to the essence of government, and may be legitimately exercised on objects to which it's applicable to the utmost extent to which government may choose to carry it. Government gonna tax, yo. Government gonna tax all the things. The only security against abuse of this power is found in the structure of the government itself. In imposing the tax, the legislature acts upon constituents. This is, in general, a sufficient security against erroneous and oppressive taxation. People might vote against you to varying degrees, but The people of the state, therefore, give to government the right of taxing themselves and their property, and the exigencies of government cannot be limited. They prescribe no limits on the exercise of this right, resting confidently on the interest of the legislature and on the influence of the constituent over the representative guard against abuse. So what is the protection against abuse outside of course, the Bill of Rights, for example, or some other limitation? What other limitations might exist other than the Bill of Rights or the Constitution of the state, which might itself impose limits? Or what other sort of limits are there? What's your ultimate limit? Your political remedies, right? The constituents might vote against you. They might pour your tea into the harbor. But the means employed by the government of the Union has no such security, nor is the right of the state to tax them sustained by the same theory, because, well, the states don't vote for Congress. So they can't, and vice versa for that matter. So there's no sort of relationship there. Those means are not given to the people of a particular state, not given by constituents of the legislature which claim the right to tax them, but the people of all states. They're given by all for the benefit of all, and upon that theory should be subject to the government only which belongs to all. It may be objected to this definition, the power of taxation is not confined to the people and property of a state. It may be exercised upon every object brought within its jurisdiction. This is true, although it's not completely true because of Dormant Commerce Clause theory, but I guess in 1819 they hadn't invented that yet. But to what source do we trace the right? It's obvious that this is an incident of sovereignty, and is coextensive to that which is incident. All subjects over which the sovereign power of the state extends are objects of taxation, but those over which it does not extend are, upon soundest principles, exempt from taxation. So yeah, the state can only regulate what it can regulate, and it can't regulate what it can't regulate, right? This proposition may be almost pronounced as self-evident. It's a little, yeah, I mean, it's pretty self-evident, that's right. Excuse me. I appreciate all the love and all the super chats, by the way, and all the people giving me cowboy hats. Those are all appreciated. Thank you. The measure of power of taxation, residing in a state to the extent of sovereignty which people of a single state possess, and confer on government, we have an intelligible standard, applicable to every case which power might be applied. That's good. Nice to have a standard which can be applied in all the cases. That's always helpful. We have a principle which leaves the power of taxing the people and property of a state unimpaired, which leaves the state the command of its resources, and which places beyond the reach of those powers which are conferred by the people of the United States to the government of the Union. So you have the power to tax except those powers that are given to the United States. Makes logical sense. And all those means which are given for the purpose of carrying out the execution. We have a principle which is safe for the states and safe for the Union. We are relieved, as we ought to be, from clashing sovereignty. Right. So there is no clashing sovereignty because they each have their separate domains. There is no clashing sovereignty. They each have separate domains unto themselves. We are relieved, as we ought to be, from clashing sovereignty, from interfering powers, from a repugnancy between a right in one government to pull down what is acknowledged to be a right in another to build up, from the incompatibility of the right in one government to destroy when there's a right in another to preserve. We are not driven to perplexing inquiry, so unfit for judicial department, what degree of taxation is legitimate, and what degree may amount to abuse of power. Now, again, this does have some limitations, at least today, because we can get into at extremes, but we can get into Fifth Amendment taking arguments at extremes. We can even get into Dormant Commerce Clause as things move between states, because we can't impose taxes and levies, for example. So there are some limitations, but you know, not much. The attempt to use on means of employment by government of the Union in pursuance of the Constitution is itself abuse, because usurpation of a power which the people of a single state cannot give. So yeah, if Maryland could tax the Bank of the United States, then Maryland can destroy the Bank of the United States, which might exist for the benefit of the other states who might very much want it. And if Maryland can destroy it, then that's a bit of a problem. You know? Lady Magala says, Night Kurt, informative as always, and you've drawn in the hubby. Excellent. Hello, hubby, to Lady Magdala. I hope you are enjoying this stream, and I appreciate you being here and learning all the things with me and Lady Magdala. You both kick ass. Thank you for being uncivilians. We find then, on just theory, a total failure of this original right to tax the means employed by the government of the United States for execution powers. Yeah, you can't tax the federal government. That's no. The right never existed, and the question whether it's been surrendered cannot arise. Yeah. Would that be Lord Magdala? Anyone know updates on Secret McSquirrel? Last I heard, she was getting out of the hospital again. But she's been in and out of the hospital, and so I think she's out of the hospital now. But obviously things are a little bit tenuous. But I think she's okay. She said she was dreading going back home because there was a lot of like housework waiting for her and stuff. So I think she's okay. We love our secret McSquirrel. Can I get some squirrel emojis in the chat? For those of you who for those of you with the scales, can I get some squirrel emojis in the chat? Are there updates on Stephanie too? Last I heard, Stephanie had her successful surgery. So things are more tenuous with Stephanie, and I don't want to comment too much. It's best left to her, to be quite honest. I don't want to, but last I heard she had a successful surgery, so that's good news. And I wish Stephanie nothing but the best in terms of a speedy recovery from her illness, as I do for Secret McSquirrel. That the power to tax includes the power to destroy. The power to destroy may defeat and render useless a power to create. There's a plain repugnance in conferring on one government a power to control the constitutional measures of another, which another, with respect to those very measures, is declared to be supreme over the one that exerts the control, are propositions not to be denied. Yeah. No problem, A. Hedinger. Thanks for correcting it, by the way. But its inconsistencies are reconciled by the magic of the word confidence. Taxation says is not necessarily and unavoidably destroy. To carry it on, the excesses of destruction would be abuse. To presume which would banish the confidence that's essential to all government. But is this a case of confidence? Would the people of any one state trust those of another with power to control the most insignificant operations of their state government? No. So the question is would the state of Maryland be willing to yield anything, even the most insignificant thing, to the state of Virginia? Of course not. Who would do that? Would Maryland be willing to let Virginia govern Maryland in even the smallest detail? No, really, no. And, there can be interstate compacts, but, that's when they're all kind of in mutual agreement on some common object to allow the other state to just we're going to control when your trash is picked up. Like, oh, no, you're not. I don't think so, right? We know they would not. Of course not. Why then should we suppose the people of any one state should be willing to trust those with the power to control the operations of the government, which they've confided their most important and valuable interests? Well, whether they're the most important and valuable is debatable. But they are conferred, whatever they are. So why would you entrust the state of Maryland to control what has been justly given to the United States? Yeah. In the legislature of the Union alone are they all represented. The legislature of the Union alone, therefore, can be trusted with the people with the power of controlling measures which concern all, in confidence they will not be abused. Not for least of reasons because the people vote for them, right? Because that's, again, your check on power. This is not the case of confidence, and we must consider it as it is. If we apply the principle for which the state of Maryland contends, can interstate compacts be regulated by the federal government? They technically have to be approved by the federal government. So yes, they have to be approved by them. So yeah, somewhat. If we apply the principle for which the state of Maryland contends to the Constitution generally, we shall find it capable of changing totally the character of the instrument. We shall find it capable of arresting all the measures of government and of prostrating it at the foot of the states. The American people have declared their Constitution and laws made in pursuance thereof to be supreme, but this principle will transfer the supremacy in fact to the states. If the states may tax one instrument employed by the government in the execution of its powers, they may tax any and every other instrument. They may tax the mail, they may tax the mint, they may tax patent rights, they may tax the papers of the custom house, they may tax the judicial process, they may tax the means employed by the government to exercise which defeat all the ends of government. Yeah, if you could tax this, you could tax everything, and that'd be dumb. This is not intended by the United States. They did not design to make their government dependent on states. Gentlemen say they do not claim the right to extend state taxation to these objects. They limit their pretensions to property, but on what principle is this distinction made? Good question. Frank says, am I reading every word of the judgment? How much is left? Well, that was kind of my plan. And how much is left? 3 pages. I mean, it's nice to read the entire thing. It's nice to read all the philosophy. I mean, you know, it's only a 29-page decision. It's only 29 pages of PDF. You know, we've read longer. We're only 2 hours into this. We're doing fine. Those who made it have furnished no reason for it, and the principle for which they contend denies it. They contend the power of taxation has no limit than is found in the 10th section of the first article of the Constitution, that with respect to everything else, the state of the powers is supreme and admits no control. If this be true, the distinction between property and other subjects to which the power of taxation is applicable is merely arbitrary and can never be sustained. That is not all. Excuse me. If the controlling power of the states be established, if their supremacy as to taxation be acknowledged, what is restrained their exercising control in any shape that may please to give it to it? Their sovereignty is not confined to taxation. That is not the only mode by which it may be displayed. That's true. If they could tax, what else can they do? Right? Why would their limitation just be taxing? If they could tax it, where else would it stop? It's like it has no limiting principle. This is a lot of how the Supreme Court thinks. They think globally because they have to. They have to think about where does it stop. And they're like, it doesn't stop anywhere. So like, well, they say, oh, we only want to tax property. Well, why? Why only property? What's your limiting principle? Okay. No. $10 from Laura, who gives me a flying peach. Kick ass. I approve of your flying peach. I should release a compilation of these as great cases as an audiobook. I don't know, man. I don't know. That'd be interesting. Maybe. It'd probably be easier to just create a voice model for my own voice and then have a machine just read it and save me time. But maybe for the future. Isn't that a pear? It might be a pear. What did I say it was? Did I say it was a peach? It identifies as a peach in the inside. You don't know its life. In the course of argument, the Federalists have quoted and their opinions expressed by the authors of the work that have been justly supposed to be entitled to great respect in expounding the Constitution. No tribute can be paid to them which exceeds their merit, but in applying their opinions to these cases which may arise, the progress of government, a right to judge of their correctness must be retained, and to understand their arguments, we must examine the proposition it maintains and objections against those which is directed. The subject of those numbers from which passages have been cited is the ultimate power of taxation, which is vested in the central government. It's a good idea of training a voice to tax to use your voice. Not the worst idea I've ever had in my life, right? The subject of those numbers from which passages have been cited is the unlimited power of taxation, which is vested in its general government. The objection to this unlimited power, which the argument seeks to remove, is stated with fullness and clearness. It is that an indefinite power of taxation in the latter, the government of the Union, might, and probably would, in time, deprive the former, the government of the states, of means of providing for their own necessities, and would subject them entirely to the mercies of the national legislature. As the laws of the Union are to become the supreme law of the land, as to have power to pass all the laws that may be necessary for carrying into execution the authorities with which is proposed to vest it, the national government might, at any time, abolish the taxes imposed for objects upon the pretense of interference with its own. I could even go so far as to like create a voice model, and then I could become a VTuber and just have an animated model of me that would read the things Man, I could really go like maximum over here, man. I could just like press play and just like read it. It's, yeah. Thank you, Frank. That's very kind of you. I'd like to be an appellate judge someday. I think I'd kick ass. It could even be a sexy VTuber. Wow. The objections to the Constitution which are noticed in these numbers were to the undefined power of government to tax, not to incidental privilege of exempting its own members from state taxation. The consequences appended to from this undefined power were that be to absorb all the objects of taxation, to exclude and destruction of the state governments. The arguments of the Federalists are intended to prove the fallacies of the apprehensions, not to prove the government was incapable of executing any of its powers without exposing the means it employed to the embarrassment of state taxation. No AI could ever replace my beautiful sarcasm. This is true. This is a fair point. The arguments of the Federalists are intended to prove the fallacies of apprehensions, not to prove the government was incapable of executing any of its powers without exposing the means to employ the embarrassment of state taxation. Arguments urged against these objections and these apprehensions are to be understood as relating to the points they mean to prove. I'm a VTuber already. Lol. Arguments against these objections and apprehensions are understood as relating to points they're meant to prove. Have the authors of these excellent essays been asked whether they contended for the construction of the Constitution which would place within the reach of the states those measures which government might adopt for execution of its powers? No man who has read their instructive pages will hesitate to admit their answers must have been in the negative. It has also been insisted that, as a power of taxation in the general and state governments is acknowledged to be concurrent, every argument which would sustain the right of the general government to tax banks chartered by the states would equally sustain the right of states to tax banks chartered by the general government. But the two cases are now the same reason. The people of all the states have created general government and have conferred upon it a general power of taxation, within the powers of Congress, to be sure. The people of all the states and of the state themselves are represented in Congress and by their representatives execute this power. When they tax the chartered institutions of the states, they tax their constituents, and the taxes must be uniform. But when a state taxes the operation of governments in the United States, it acts upon institutions created not by their own constituents, but by people over who they claim no control. It acts upon the measures of government created by others as well as themselves, for benefits of others in common with themselves. I have powerful masculine forearms and should include them in the shot. I'm getting there. I've been logging my workouts. I started logging them on YouTube instead of Instagram because I was like, why am I doing this on Instagram? Upon reflection. But I'm trying to get buff. I've got a long way to go. Although I did look at the scale and I was down another 4 pounds. So I've got a long way to go there too. Got a long way to go. Long way to go. Should be interesting. How long is his opinion? We're on page 28 of 29. We're almost over. But if the full application of this argument could be admitted, it might bring into question the right of Congress to tax state banks, and it could not prove the right of states to tax the Bank of the United States. So just because the United States might be able to tax the banks of the states does not imply the states have the power to tax the United States banks. The court has bestowed upon the subject its most deliberate consideration. The result is a conviction the states have no power, by taxation or otherwise, to retard, impede, burden, or in any manner control the operations of constitutional laws enacted by Congress. That is as much true today as in 1819. They don't have to help, but they can't interfere, impede, burden, restrict. Right? They don't have to help, but they can't harm. That is, we think, the unavoidable consequence of the supremacy which the Constitution has declared. We're of unanimous opinion the law passed by the legislature of Maryland imposing the tank is unconstitutional and void. That opinion does not deprive the states of any resource which they originally possessed. It does not extend to a tax paid by real property of the bank, in common with other real property within the state. So they can tax the property the same, at least they could in 1819. I'm not so sure about today, but they could then. Nor is a tax imposed on interest with the citizens of Maryland may hold the institution in common with other property of the same description throughout the state. So to the extent that citizens of Maryland hold property there, they can tax that property. But this is a tax on operations of the bank is consequentially a tax on operation of the instrument of the government. And that brings us to the end of the opinion. So, good times. That's good times. So, pretty interesting stuff, I think. Runkle the Bailey says, hey folks, finally here, what did I miss? Everything. We just wrapped it up. You missed me reading 29 pages. But let me give a full summary. Let me give a summary of what we read. What we read was perhaps the first, well, I don't know if it was strictly speaking the first, but it's probably the most important expression of the necessary and proper clause of the Constitution. The Constitution gives the federal Congress certain enumerated powers. In Article 1, Section 8, for example, among some other places, but Article 1, Section 8, including, for example, the power to make coin, the power to tax, the power to have postal roads, the powers to create patents and copyrights, and some other stuff, right? So there's all these powers that Congress has explicitly. And then there's this clause that says the Congress also has the power to make necessary and proper laws that would further the laws that were expressly described. So the question is, okay, what does it necessary and proper mean? And the Supreme Court spends a lot of time on the word necessary. And they do note that in the Constitution, there at least one place where the Constitution uses the phrase absolutely necessary when it refers to states' power to impose fees as absolutely necessary towards its inspections. So the Supreme Court makes the very reasonable determination that every word in the Constitution must have some sort of significance, that no word should be ignored, and that absolutely necessary and necessary therefore must have different scope, which, yeah. So therefore necessary is broader than absolutely necessary. How much broader? Well, we learned that basically anything that is not forbidden is permitted. Right? So that is the law as it exists today. Right? If we were analyzing Congress's actions today or state action today, our typical go-to is rational basis. Typically, unless some provision of the Constitution is a restriction, right? Unless there's a First Amendment interest or a Fourth Amendment interest or something, right? Unless there's some other interest in which would elevate the scrutiny, right? If we're just talking about normal power of government to do stuff, we're talking rational basis, which allows the government to employ any rational means towards any legitimate end. What are the legitimate ends? In the case of the federal government, the ones provided for by the Constitution. In the case of the states, everything else. What are reasonable means? Any means that have any reason. Any reason will be fine. Anything that makes any rational sense. And so they say, okay, first of all, does the federal government have the power to establish a bank? Yes. Why? Well, they have all these explicit powers, the power to coin, the power to, the power to raise money, the power to spend money, the power to control control a federal military. And if they didn't have the power to have a bank, that would be like really weird, because how are they supposed to like raise money and spend money without a bank? And Maryland's like, oh, you can use our banks. And I'm like, the federal government's like, I bet we can. Right up until the time you tell us we can't, and you want to charge us some sort of massive fee or prevent us from using it or whatever. You want to impose restrictions on us, right? So if you literally hold our money, you might prohibit us from using our money freely or something, right? Or you could tax our money or whatever, and that would be dumb. So it's like, okay, first of all, yes, you have the power to establish a bank, or today, a Federal Reserve. That's fine. And then can Maryland tax that bank? No, because the power to tax is the power to destroy. And if Maryland had the power to tax, they have the power to destroy. They have the power to destroy the national bank by taxing it to death, if they wanted to. And they would therefore be able to impede on the power of Congress. So the states cannot tax, nor can they do anything that would inhibit the legitimate actions of the federal government. They don't have to help. We learned that from cases like Prince versus United States and Murphy versus NCAA. They don't have to help, but they can't do anything that would impede. So they might be able to impose property tax on the property the same way they do for any property. They might be able to charge people who have deposits at the bank the same way they do any other person at the bank, but they can't charge against the bank itself because it's an instrumentality of the federal government. And so that's basically what we learned. And by extension, we learned how the federal government has power as it relates to all the enumerated powers, because, again, for example, the Constitution gives power to Congress to create postal roads and post offices, but it doesn't explicitly allow them to, collect mail from people's homes or transport the mail between states or even punish people for stealing mail. But that's all like kind of dumb. If they didn't have the power to do that, that would be a little bit dumb. And legislatures have the power to legislate, and they have the power to make things illegal that to protect their interests. So it's like, yeah. So in a lot of ways, this is very sort of basic and simple, but it's a basic, simple case that's the foundation of federal power today, and is also the basis of because this logic, by the way, would also work as it relates to state power. It would work the same. So you could just copy paste that, and then of course the federal government is supreme vis-a-vis the state government. So we read this 29-page decision for the last 2 hours to go over it in detail and try to go through the exact reasoning of the Supreme Court, and I think it's pretty persuasive. I think it's an unbeatable argument. I think it's an unbeatable argument that absolutely necessary must be distinct from necessary, because if absolutely necessary and necessary meant the same thing, that would make a word in the Constitution redundant, and we don't do that, right? We want to give every word in the Constitution meaning. We don't want to render a word redundant. So absolutely necessary must be distinct from necessary. So it must be broader. And then, well, what are the limitations of that? And the court basically says, well, any limitations other than those expressly provided for example, by the Bill of Rights or somewhere else, would be a political question, and it's not for us to decide. And that's basically the standard as it is today, more or less. So that's all the things we learned today. So that's what we learned about all those things. So I found it very, very interesting as well. And I hope all of you did too. And the power of the federal government to tax on states doesn't necessarily imply the power of the states to tax on the federal government, because the federal government is supreme. So to the extent the federal government would have power to tax state banks, for example, it doesn't imply that states have the power to tax federal banks, because they're different governments with different powers and different scopes. And to say one government has the power isn't necessarily to imply the other government has the power. In fact, it kind of implies the exact opposite. If one government has the power, it's very unlikely the other government does, because they're usually like, the entire atom of sovereignty, right? The entire atom of sovereignty was split between the federal government and state governments. So the state governments have all the power except that which has been expressly provided to the federal government. So all the power has been split between the states and federal government. So both the federal government and the state governments are sovereign at the exact same time. They're just sovereign in different domains. The states have all the power except for the part that they gave the federal government, and the federal government has that power, and they're both sovereign in their respective domains, and the domains don't conflict. So this is why the state governments and federal governments can have their own set of laws and their own set of police and their own set of everything, and why, the federal government can't necessarily do certain things and with respect to states, and why the state governments can't do things with respect to the federal government, and so forth and so on. It's all part of our constitutional bargain, the federalism that is the basis of our constitutional framework and separation of powers. It is all kinds of fun and exciting. Tilly T was gifted a membership by Law and Limber just now. Okay, cool. I was confused. Ellie says, you're super late and annoying. I keep getting shadow banned. I'm sorry about that. So, all those good things. So, I'll answer questions for just a second if there are any more questions, and then I'm going to wrap this up. So, are there any last questions or points of clarification or things that I can explain better or try to clarify in some way? Can HB 20 be used against all the shadow banning? You mean the Texas thing? Maybe. I mean, it's still working its way through the court system. I've been reading articles about how it's like horrible and really, really bad legally. It's been interesting reading different people's interpretations of the thing. Have I tried creatine to help my workouts? I've tried creatine in the past. I find it very difficult to use on a regular basis. Maybe if I took it in pill form, which isn't as great, but I find it very difficult to remember to take creatine all the time. But it's a thought. Maybe I should get it in pill form, and then I could put it in my pills that I take every day, and it might not be as much creatine as I would take in. But I always forget to take it. You're so thorough, you usually cover it all. Thank you, Generous. I try very hard. How did the 1936 gun law NFA happen after reading they can't tax in a harmful way? The 1936 gun law NFA is a federal law. We this entire time we've been talking about state law and state taxes on vis-a-vis the federal government. The states can't tax in a harmful way. The federal government's ability to tax is an entirely different proposition. So if you want to analyze the taxing power of the federal government, we have to have an entirely separate discussion. What we've been talking about this entire time is the ability of state governments to have taxes on the federal government, and that's a no-no. You can't do that. Would I ever juice to get to my goal physique? Probably not. Not for at least the reasons that I wouldn't necessarily trust the source. I wouldn't necessarily trust the source. That's the problem with the illicit things, is like, how do you know that you're getting what you're supposed to be getting? It's a real problem. Unless you synthesize it yourself, which I'm not even sure how you would go about doing that. I do check my hormone levels and blood work. I haven't checked them in a while, but I have checked them in the last year. I'll post this quote again for you, Kurt. Working out will make you feel weak when actually making you strong. Fair. We have a lot of work to do when it comes to gun rights. Keep in mind you weigh yourself if muscle weighs more than fat. Look more for how your clothes fit than the numbers. The numbers are pretty depressing, man. They're really bad. Would I try electroconvulsive therapy for depression? I might. I mean, because that is regulated. You know, that is like... That is obviously something that can be done in a professional setting, in a professional way, in a regulated way. So it's therefore something worthy of consideration. Yeah, I can. Frank, I am aware that it can help people when nothing else has worked. Right now, I'm looking into what's it called? Ketamine. I'm trying to get that resolved. Best cure for depression is being outside during the day. You like these background colors? Yeah, this is the violet triad. That is violet, green, and I believe gold or something in the background is on the triad. Vitamin D, I take vitamin D every day. I take 5,000 IU. The problem with mushrooms, again, is like it's illegal. There's nowhere I can go buy mushrooms. And I wouldn't trust any source that I could buy them from, even if I could, because since it's not completely unregulated, I wouldn't know what I was getting. Psilocybin, yeah, the problem there is it's not legal in Texas, and I wouldn't trust buying it from anyone on the street. First of all, I wouldn't know where to buy it, even if I wanted to. Second of all, even if I could, there's no way for me to trust the source. There's no way for me to regulate it. So it's completely impossible. D3, yeah, D3 is what I'm taking. Oregon, Washington, D.C. All right. Yeah, even if I wanted to, I wouldn't trust any source because they're not verifiable. So even if I wanted to take illicit medicines, I wouldn't do it because they're completely unvettable. It's like you can never be sure. So all right, I'm going to sign off for now. I hope you've enjoyed the stream. As always, my friends, I will Ask you to like, comment, subscribe. Until there, my friends, I hope all is well.